comprehensively and effectively in these types of cases. We have decided, therefore, to set up a dedicated Community Relations Unit, or CRU. Under the new Part 2A, the bill proposes for CRU officers to have a range of powers to investigate, take decisive action in neighbour disputes that involve unreasonable interference. Officers may investigate, for example, by taking statements from neighbours, or take photographs and recordings, which can then have evidential value. This can help ameliorate cases which very often we see descend into a he said, she said, there's this noise at that time, or this volume and that volume. I think this helps to cut through all that and allows objective statements and evidence to be taken. Under the new sections 13I and 13J, the CRU may also leverage on technology and deploy noise sensors with consent to collect objective evidence of noise events. After investigations are completed, officers may issue advisories or warnings as appropriate. These warnings or advisories do not carry penalties in the first instance. But if they are not heeded, then an abatement order under Section 13L may be issued subsequently. An abatement order can require the recipient to stop any acts that are causing unreasonable interference to surrounding neighbours, and it will be an offence under Section 13L, subsection 5, to disobey an abatement order without reasonable excuse. I hope we do not always have to resort to issuing an abatement order. Let me explain the thinking behind the role of the CRU and the scope of its powers. The statutory powers that will be conferred on the CRU in this bill under the new Part 2A have been drafted to cover a range of matters. These are matters which usually cause community disputes. They can cover a wide range of acts or omissions which can lead to unreasonable interference with the neighbour's enjoyment or use of place of residence. And this is intended to cater for flexibility in the CRU's deployment to allow it to do its work effectively. However, it is not intended for the CRU to become the first responder in all cases, and that is simply not possible. The CRU will focus its resources only on severe neighbour noise cases that are causing disamenity to the community, and also severe hoarding cases. The CRU will, of course, have discretion to judge the severity of these matters and cases, having regard to the specific facts and circumstances of each case. And we will reflect this in subsidiary legislation made under Section 13Z, read with Section 13G. I would also like to caution that we must strike a balance between the CRU stepping in to manage dispute and also at the same time leaving enough room for neighbours to settle the private disputes between themselves. We intend to first pilot the CRU in the HDB estate of Tampines Town. The learnings from this pilot will help us understand how to effectively scale up these operations and make it effective and efficient island-wide. During the CRU pilot in Tampines, grassroots leaders and frontline agencies will continue existing efforts to manage neighbour disputes, both in Tampines as well as applying in the rest of Singapore.
The Minister to issue mediation directions. The CRU will comprise the Director General, or DG, as well as other authorised officers to be appointed by the Minister, and the Community Relations Officers and Auxiliary Community Relations Officers appointed by the DG, or CROs and ACROs for short. We will equip CRU officers with powers to carry out their tasks and also put in appropriate safeguards. First, under the new Section 13E, before exercising any power, CROs and ACROs must identify themselves by showing their official identification card. Members of the public will be able to go to an MND webpage to verify that the person standing before them is indeed from the CRU. Impersonation of a CRU officer will be a criminal offence under Section 13Q. Next, under the new Section 13I, CROs will have powers to take statements, photographs, and recordings. They may also issue advisories and warnings. These are standard powers for public officers who perform enforcement functions. Advisories and warnings do not carry penalties. However, if they are not heeded, further enforcement action may be taken. CROs will also be empowered to leverage on technology to perform their work. In particular, under Sections 13I and 13J, CROs, assisted by ACROs, may deploy noise sensors to collect objective evidence on matters such as the direction, timing, and intensity of the noise nuisance. This addresses a gap today, where complainants attempt to collect evidence by making simple audio recordings, often on their mobile phones. These recordings are unable to tell us the intensity or direction of the noise disturbance. They can also easily be distorted upon playback or edited, and therefore cannot be relied upon for official investigations or court proceedings. The deployment of noise sensors gives us a sensible alternative to deploying officers on long and possibly futile stakeouts. We also hope sensors can deliver evidence in cases where the nuisance maker stops the noise when officers are present, but starts making noise again once the officers have left. In relation to the deployment of noise sensors, I would like to assure members there will be safeguards to protect residents' privacy. It affects not only the hoarder, but also surrounding neighbours. In severe hoarding cases, the home may be infested with pests due to rotting food. The accumulation of clutter is also a potentially fatal fire hazard, as occupants may be unable to escape if a fire should break out. The pests and stench may prevent surrounding neighbours from the normal enjoyment of their own homes. Now, the root causes of a hoarder's behavior are complex. They could be due to trauma, grief, or underlying mental health conditions. And given the complexity of the issue and the hazards it causes, the government has been taking an interagency approach to address the issue. There is a Hoarding Management Core Group, or HMCG, led by the MSO to coordinate efforts across agencies to resolve protracted and severe hoarding cases. Agencies adopt a concerted approach combining enforcement efforts with community and social interventions. Together with community partners, we have made some progress in reducing the severity of many hoarding cases. To better address severe in-unit hoarding, Clause 11 of the bill inserts a new Section 11A into the CDRT. The provision empowers the DG to apply to CDRT to declutter a residential unit as a measure of last resort premised on public interest, and only after existing regulatory levers from frontline agencies have been exhausted. This is necessary to protect public health and safety. The DG may apply to the CDRT for an order to address hoarding under the new Section 11A after the CDRT has found the hoarder to be causing unreasonable interference to the hoarder's neighbour and the hoarder has failed to comply with the CDRT's order to declutter. If the order to address hoarding is granted by the CDRT, then CROs will be authorized to enter the unit in question, remove and dispose of any hoarded materials and/or items that are causing unreasonable interference, and take any other actions as specified by the court. MND, MCCY, and MinLaw consulted extensively on the enhancements to the CDMF and, in particular, the CRU framework. In the course of our consultations, many members of the public expressed strong support for the CRU, and some have even asked when the CRU can come by their unit and conduct enforcement on their neighbour.